And welcome back, everybody, to the Law and Crime Network. I am your host for this afternoon, Rachel Stockman, and we are live. You saw it right there inside the Riley Gaul murder trial. It's a trial we're closely following here on the network. I'm here alongside frequent guests, Mark Eiglarsh, criminal defense attorney out of Florida, and Vinoo. Thanks so much for joining us here. Talk to me about the defense in this case. This is what I want to get at. Both of you are criminal defense attorneys. What do you make of this, Mark?
It's what they've got to argue. It's not a whodunit, it's a why. So they've got him. He pulled the trigger. He asked a friend allegedly to get rid of the weapon. It's him, it's him, it's him. Even when the parents walked in on this abhorrent crime and saw their daughter dead, immediately he was the first person that came to mind. So clearly it was him. The question is why? Why did he do it? And what the defense does, which is always the best strategy, is they embraced most of the elements of the state's case, except for the one regarding intent. He didn't mean to kill her. He just wanted to scare her. And that's where the state may fall short of proof beyond a reasonable doubt. That's what they're hoping.
Well, and I found it very interesting. We were just listening on the stand, a friend of the couple's talking about a scenario that happened earlier involving a text message, Vinoo, where Gaul had allegedly, or we call him by his first name, Riley, had sent Emma Walker a text message through this secret kind of encrypted phone, basically to scare her. And this kind of plays into the defense's theory that he wanted to be kind of the hero here, right, and rescue her, I guess. What did you make of that testimony, Vinoo?
I think in the end, I think all of this is going to be problematic for him because you have a young girl who's very attractive who, you know, was stalked by this guy. And, you know, the idea that he's crazy, you're going to have to get these 12 jurors to say, well, yeah, you know, he didn't intend it. He was trying to scare her, but he never meant to kill her. I don't think they're going to have much sympathy for him. And I think that all of this, while I think it's the only thing the defense can do, and I agree with Mark on this, I think the problem here is that, I mean, this is just, I mean, what are the chances of shooting into a room and then getting her while she sleeps in bed? I mean, it's
well, that's why I got to push back a little on that. Is I am kind of almost a little bit buying the defense's theory in all of this. I got to say, because listen, this was a hormonal teenager. He had a tumultuous relationship with this 16-year-old Emma Walker. I mean, this is high school. He was in college at the time. They were off again, on again. The parents, Emma Walker's parents, did not like the relationship. So the fact that he would try to set up these creepy scenarios to kind of scare her, to try to get them closer, I kind of buy it, maybe.
I would think that there are people on the jury who are going to be like, what if this were my kid? Right? And it depends, I don't know what the jury composition is, but this is the kind of thing. Look, the defense is doing everything they can, and the only thing they can do. But I think that, you know, this is going to be a big problem. I mean, you have a dead girl whose mother found her in the sleep. I don't think there's going to be much sympathy for this guy.
He's 100% correct. When I heard about the fact, but there's a but after this. He's 100% correct in that the facts are horrible. We're talking about how the parents came in and saw what they thought was vomit, but it turned out to be beans, like horrible stuff. Like, we got to get down to it. So the jurors, they're going to hear that. He's absolutely right. There's going to be sympathy all over this place. But the right lawyer, okay, attacks this in jury selection and says, folks, you're going to hear some unbelievably graphic testimony. There's going to be sympathy everywhere. You've got to promise us that if we select you on this jury, that you're going to set that aside. And then secondly, you find jurors who take their oath very seriously, that yes, if there's proof beyond all doubt that he caused her death, okay, check that off, but that there's a reasonable doubt as to whether he intended to murder her, that you have an obligation to say not guilty, even if you're consumed with emotion, which we expect you to be. And I think if you get the right jury and you handle this correctly and you act almost tougher than the prosecutor by showing this was outrageous conduct, no one's approving of it, it caused tremendous tragedy, you really got to embrace that. And you say, however, this kid whose frontal lobe of his brain wasn't fully formed, came up with this stupid plan that tragically led to her death, but he never intended on killing her.
Well, and let's think about this for a minute now. He'd set up other scenarios like we talked about and the prosecution talked about in the openings to scare her, and she actually physically ran to him afterwards, you know, to be with him. Okay. So if if he wanted to kill her, if that was really his motivation, why wouldn't he have just set up a scenario to give him a much better shot than through a window outside in the dark, Vinoo? I mean, that's where I come out with this.
I'm hearing what you're saying, but I want to go back to what Mark just said about how the defense should make the arguments, and I agree with him 100% that this is something that you've got to set forth in jury selection. You've got to try to weed as many of these people out as possible. I think the issue that he's going to have is that in the end, the state's going to come back and say this boy is not worthy, or they shouldn't use the word boy. Obviously, if they do that, that's going to hurt their case. But if this adult knew what he was doing, he's a terrible person, and you know who does this kind of stuff, right? He had to have known that shooting into the room could have killed her, right? And that's not an unreasonable statement.
But no, hold on one second. That's what the defense is going to argue. The prosecution's charging him with intentionally causing her death, that he wanted to kill her. And we're both buying into the thought process that there may be reasonable doubt there. I ask you point blank, pardon the pun, what specific piece of evidence are you aware of that makes the defense argument inconsistent with what they're alleging? What's missing?
I'm not saying there's anything.
I got something, Mark. Okay,
yes.
Now because I like to play both sides. Okay, what about after the fact, the extent he went to
Yes.
basically cover this all up, right? I
And he
mean,
would have
that's
done
a pretty
otherwise.
guilty person there.
Well, he's not denying it, and he pled guilty is what the defense is going to argue, right? He pled guilty, and yes, those lengths that he went through after the crime is consistent with someone who is guilty. We're not saying he isn't. He is guilty. Ladies and gentlemen, he admitted responsibility for what he did. So what he did after the fact doesn't prove that essential element any more than anything. That essential element is he intended to kill her as opposed to being the hero like you advanced earlier.
Okay, Mark's doing a better job than his defense attorney right now in convincing me that this guy is innocent, Vinoo.
I will say, Mark, that there's a little problem with the last part of what you said, which is that the prosecution is going to argue this is all consciousness of guilt, which is where Rachel.
That's where I was going with it.
That's the argument they're going to be making. Now, I'm not sure specifically in the state whether there's a charge for that, but I know in New York there's a specific charge that shows certain elements, certain things you can infer this was a consciousness of guilt. But I actually want to go back and want to add one more thing to what you were saying about how to argue in front of the jury. I think I would take a different tact if faced with these facts, right? You're going to talk to them in a very soft tone. That's the way I would do it. I was like, look, folks, this is terrible. This shouldn't have happened. You know, this guy he's just a lovesick boy who, you know,
I'm not buying you, Vinoo, not for a minute.
I'm telling you,
please.
That's the way I think.
Not buying it.
Because I think if you take the harsh approach, I think that, Mark, I think you run the risk of taking away any sympathy for this guy.
Well, Vinoo, I've been trying cases 25 years. I don't stay at one level.
He has
There's
two.
levels. Right, but there's many levels to what I do. That one dramatic performance that I gave earlier was good for TV, but I assure you in a courtroom it gets old. Trust me, there's many layers to the way that
I'm just saying, I think that this is a tough case, obviously, right? And that's why I don't know if these are public defenders or they're retained. I have no idea. But these guys
one
are doing...
attorney. He has one attorney, actually.
But you guys, we're getting back down to it. All you both had to say was the things that he did afterwards, consciousness of guilt. He would have done those things even if all he did, and I say that in quotations, was shoot into a wall to scare her. In other words, what you're suggesting is that he wouldn't have gone through lengths to hide the shooting and hide his identity if somehow all he did was shoot with intent to scare? No, that's a serious crime for which he could go to prison for many years. He's going to shield that the same way he would a potential first-degree murder.
But the prosecutor, of course, could argue, well, really, if this was a huge mistake and he just meant to scare her, he would have come to his senses and said, oh, my goodness, I am so sorry. I went there, I did this terrible thing, but I didn't mean to kill this woman.
No, that's if he sent her a note that he feels bad about. When you pull a gun out and start shooting into a wall, you are in felony land. And even any kid whose brain isn't fully developed knows you're in a serious ballpark, and you must go through great lengths to ensure that nobody knows it was you who did that.
All right. Well, okay, I want to turn now to another issue in this case. And this is where we have the prosecution doing a bit of what I'd call maybe creative lawyering, and that is they tacked on a felony murder charge to a aggravated child abuse charge, where what they're hoping for, I assume, is if they can't get that intentional murder charge that we all have been debating back and forth, then perhaps the jury will find him guilty of child abuse, and therefore, of course, the felony murder would attach to that. What do you make of that strategy, Mark?
Feels like a law school exam, right? When you spot issues and you say, this is what you could charge her with, right? Right? But as I sat there preparing for this very important appearance, I analyzed it and I said, well, I guess it fits. I mean, it does. And if jurors are going to do exactly what Vinoo says, take their job seriously and not have sympathy, they're going to want to find him guilty of everything that he did. And I think it could fit.
Vinoo?
I think this is just a classic case of prosecutors piling on and throwing everything out there, see what sticks, and you know, it actually concerns me if I were the prosecutor, and I was a long time ago on this case, I wouldn't have added this charge, because I don't think you want the jury to go down this route. I think you want them to have a couple of charges and say, okay, this is what you're gonna, and argue strongly for it, because this is I think if you get to this point, you're in bad shape if you're the prosecutor.
Yeah, and I think it's a little bit of a cop-out by prosecutors when they start piling on the charges because they're just hoping for a conviction. Listen, I mean, the duty of a prosecutor is to get justice, right, Vinoo? You were a prosecutor.
It's funny. I've gotten to the point now where I'm not sure anymore. You know?
Hold on.
Push back to both of you. Can you tell me, because I might have missed it, what element isn't satisfied in that charge? So why isn't he guilty of that charge?
Well, they have here, it says child abuse is under Tennessee law, child abuse is a knowing treatment of a child under 18 in such a manner as to inflict injury. Under the law, aggravated child abuse is abuse which results in serious bodily injury to the child or where a deadly weapon is used to accomplish the act of abuse.
Serious bodily injury. So if he's claiming, of course, that he was only doing it to scare her, then, you know, he didn't intend to inflict serious bodily injury. And that's a component of the charge. So there
you go.
All right, let's switch
I think Mark would agree with me. This is just prosecutors piling on. Wouldn't you agree, Mark?
If I'm paid to zealously defend, absolutely.
Okay, so it looks like I want to turn really quickly, and we can show a live shot, hopefully, into the Shawn Grate. He's an accused serial murderer, and we have been following this trial very closely out of Ohio. I'm just told by my producers that the defense rested their case. I'm not even sure if they presented a case, but they've already rested because we were in this other trial. I'm not even sure they had a witness. But this morning, a very interesting thing happened, and we actually had a bit of a plea agreement where Shawn Grate agreed to plead guilty to several of the lesser charges, including, and I'm just pulling it up right now, the burglary charges, the rape charges, the gross abuse of a corpse. And the reason he did this, we think, is because he didn't want the videos, and this is very horrible to think about, but there were actually videos of him raping these women. He didn't want those videos presented to the jurors. Mark, do you think this was a smart defense strategy? Because, of course, this is a death penalty case here.
Yes. And I finally get to say smart defense strategy in this case. I haven't been able to say anything's been smart. So far, the only defense strategy I saw was hire 2 middle to late age bald guys as your defense lawyer and put them on either side of you so I can go, what the hell is going on there? Otherwise, there's nothing here. This guy, it's life, for sure, and maybe worse, and they've got nothing to work with here. The guy went around and admitted to anyone he could tell, what he did, and so these defense lawyers are doing the best they can with what they've got, and it ain't much.
Well, and of course, if they want to spare this guy's life and
Right.
try to ensure that jurors aren't going to put him to death, showing videos of him brutally raping women, if any juror is ever going to want to put someone to death after they've seen something like that, I can only imagine. Vinoo, what do you make of this? I mean, this is really now, why are they even going forward with this? Because they don't have much of a defense even on the more serious, I guess you could say, murder charges that he's facing.
All I know is that the lawyers had gotten and received permission to hire a neuropsychologist and get a certain type of MRI done to show some type of deficits in his brain. I think that was a good strategy to start going down. I don't understand if they didn't present the case. That really gives me a great cause of concern here, because where do they go with that? They
well,
got
I
the
wonder
approval.
if that's something that might be presented in the penalty phase of this.
That sure, but you also want to lay the foundation for this to some extent, to the extent that they can. Maybe there was a pretrial ruling that said they couldn't. I don't know, but it is concerning to me.
So you're saying you think the defense should have at least put some of these expert witnesses on the stand before arresting?
I think that they should have at least tried to go insanity.
No, there's going to be a penalty phase probably in the next, listen, this is all about the penalty phase. He went around and told everybody he's guilty. So this is really just something that has to be done before he then gets to the penalty phase. This is all about whether he's going to live or die, and them shielding the jury from seeing certain abhorrent acts is the best they can do. Maybe they'll argue down the road, as lawyers argue, ineffective assistance of counsel, since these guys aren't doing much, but they don't have much to work with. This is all about second penalty phase. It's all about what happens to them, live or die. That's all.
And it looks like
But I
now
think that's where they have to worry as lawyers. You don't want to set up a case for being claimed to be ineffective. So the question is, are you doing everything that you're
Wait,
doing?
Mark, why would any attorney ever be incentivized to set up a case where they're found to be ineffective counsel? Wouldn't that look poorly on them, even if down the road maybe it could save Sean Great's life?
Wait. Look poorly? What lawyer who feels so unbelievably passionate that death is wrong and should never be issued in any case gives a crap about what people think of them? So they're doing everything they can to save his life. And if that means setting it up, and trust me, lawyers do it all the time, setting up an ineffective assistance of counsel by not calling certain witnesses, that's.
I am shocked by that. That sounds like professional misconduct to me. I mean,
you're taking an ethically dubious position, my friend.
I'm doing it. Hold on. Let's make something very clear. Number one, I have never done it. Number two, that's different than me saying that lawyers who care about their clients, some who literally drop tears when their clients get death, they so don't believe in the death penalty that they do it. Me calling them out on it is different than me doing it. It happens.
Well, I'm not saying you do it. I just think the position is a dangerous one, and I don't think any lawyer should be trying to set up an ineffective assistance of counsel argument for appeal.
But I see Mark's point. Basically, this is like a social justice warrior. Right. Social justice warrior that takes these cases on because they so oppose the death penalty. Interesting theory, my friend. Okay, it looks like, from what I can tell from my producer, that they're giving jury instructions or discussing jury instructions in the Sean Great trial. It sounds like the closings in this are going to be on Monday, so we're going to have a little bit of a break, and then, of course, they will move on to the penalty phase. It looks like they're breaking for the day, I think, for the rest of the week as well. So I want to turn now back to the other case that we have been covering, and that is the Riley Gaul case. And if you're just joining us, this is the former college football player who's accused of killing murdering his ex-girlfriend, on and off again girlfriend, Emma Walker. Very tragic case out of Knoxville, Tennessee. Let's play some more of the prosecution's openings. Let's take a listen. Riley Gaul, what was he thinking with some of these tweets, some of these text messages, some of what he did after this shooting? I'm here with Vinoo Varghese and Mark Eiglarsh. I'm sorry for mispronouncing your names there, a criminal defense attorney out of Florida. What do you make of these openings? I'm all over the place right now. This was the prosecution laying out the case against this guy, Mark.
Well, he's hardly likable, this defendant, according to the prosecutor, and he's doing a good job of what Vinoo said, and if I'm assuming I'm saying his name correctly, of making him out to be just a horrible person. It makes it more likely then that they're going to give the prosecution what they want in a close call. And as a defense lawyer, I get up there and I am just as harsh on my client. And I say, you know, what he did was reprehensible. It led to the tragic demise of somebody that he actually cared about in spite of the on again, off again, difficult, challenging relationship that they had. But he had no intention to kill her.
Vinoo?
I think, Mark and I are in agreement on this. Maybe tone, we were talking earlier, maybe we use a little bit different tone depending on how you do it. But I think this is as tough a case, for the defense lawyers as you can imagine. I mean, again, the prosecution has a lot of things going for them, particularly here. You have a very, attractive young girl, cut down, cheerleader, all this stuff is going to play. So, the defense has to get creative. I mean, and I think that, the idea of attacking him is right. But I think you want to portray him as a troubled boy and say that all of this is just, he's not inherently, I think you have to make an argument, while you can be hard on him, I think you have to make an argument that he's not inherently evil, that he's just a very troubled soul who went too far, never intended to kill her. A lot of this is typical teenage angst, right? He's in college, but he's only a freshman. This is typical stuff, and I think that it just went too far. He didn't know how to control himself.
Let's talk a little bit about this plot that apparently the police hatched, basically wiring up the two friends and catching this guy as he was about to dispose of the weapon. I guess in a scenario like this, I get why they did it, because it's this dramatic moment that they can present to the court that, we were arresting these guys and he was about to throw out the murder weapon. But did the police really need to do all of that?
I'm not sure they needed to.
Yeah, why? They knew who this guy was.
I think
are they watching too much SVU or something that they think they have to do stuff like this?
I think it's for the flair, for the dramatic, to give the prosecutors more stuff to work with. I think you hit it on the head. I just don't know they needed all this stuff.
Because when you set stuff up like this, it also, while it is more dramatic and it gives great theater, I guess you could say, in the courtroom, but then it potentially opens up the police to problems down the line when you have a case where, this wasn't even a question. They knew a lot that he had taken the gun. The grandfather said the gun was missing. They had these statements from the friends saying he had the gun. They had text messages, apparently. I don't get it.
It reminds me of a case that I was on for about a year, the Dalia DiPolito case, where they got her on video, and I don't say allegedly anymore because the jury convicted her, saying that she's 5,000% sure that she wants her husband dead. And then they could have stopped there. But what they did was they set up this scene at the crime scene where they put up tape, and just to get her reaction, they told her, so they can get it on video, your husband's dead, and then she cries hysterically. Not only wasn't that necessary, but it served the basis as the defense for at least, two of the trials. It just wasn't smart police work. I don't know if this is going to backfire this case at all. It's just, when it's not necessary, just don't do it. That's all.
Yeah, I mean, exactly. In that case, it did backfire. In this one, we don't know. I don't think that we haven't gotten any evidence that there was anything improper in doing that. But I'm sure, you know, the defense attorney, if he can find anything, dig up anything, he certainly will, because it's always a little bit unusual when you have cops set up a scenario like this. Even though in the trials we cover, it seems to happen a lot. But these are and you can tell me, you are a former DA here in the Brooklyn area. I mean, you don't generally see situations where the cops stage this whole thing or make guys wear wires in order to catch the perp.
They can.
Yeah.
You know, it really depends on the case. There was a case actually out of Brooklyn years ago where the cops went undercover to catch a guy in an act, and they filmed him, they taped him. They got a lot more than they probably needed to do, but you know what it does is it solidifies a case. But going back to what you were saying, whether it was necessary or not, I think it really goes to the idea there's a mentality amongst police officers. Why do they do this stuff, right? Why are they police officers? Well, there's a feeling of a certain bit of righteousness there, that they are righteous. They're doing God's work. You know, cops and prosecutors hand in hand to do God's work to keep society safe. You know, when they had this guy, they should just arrested him. I mean, the case is strong, as you said. You know, who knows? They could have potentially led to a situation where he got away, right? I mean, that's always. I mean, then
it could have totally backfired,
right? Or he shot somebody, you know, in the process. So there's.
He could have figured out one of them was wearing a wire, threatened them. Then you're putting these teenagers at risk. Listen, I just think that there's a whole host of things that could have gone wrong. I'm glad they didn't in this scenario, but I think it's very, you know, not only does it, as Mark was alluding to, leave the police and the case up for a potential review down the line in an appellate issue, but also a safety issue. You've got a guy with a gun, right, that's kind of emotionally unstable as far as we can tell. He was pretty according to his friends, he was suicidal. So I personally think it was a risky move what they did. If they thought this was the only way they could catch him, they thought he was going to run, maybe, but I think it's a little bit questionable. Now, I know Mark Eiglarsh, a criminal defense attorney in Florida, has to go, so we will say goodbye to him. We always appreciate his insight. Peace out, Mark.
Nice to see you guys. Nice work. Way to go.
All right, and we'll see you next time. We love having Mark along. And I also wanted to apologize to Vinoo. I mispronounced your name again. Varghese, right? I got it right?
Vinoo Varghese.
Vinoo Varghese. I keep pronouncing his name wrong, and that is very rude. We should not be doing that to guests, so I apologize.
We've known each other for a while.
I know, we've known each other for months. We go way back. Okay, so I want to now turn back to this case that we've been following. This case of this college football player accused of killing this cheerleader. He admits to shooting her, says it was not intentional. And yesterday, when the case began, we had Emma Walker, the victim, 16 years old, beautiful woman, young girl, I should really say, her mother. She took the stand and she talked about, you know, how she really wasn't a fan of the relationship. And she really didn't really like Riley. Let's take a listen to some of what she had to say. Listening to Jill Walker. She is Emma Walker's mother. Emma Walker, of course, is the victim in all of this. This is the case of Riley Gaul, a murder trial that we are following out of the Knoxville, Tennessee area. 19-year-old, at the time anyway, charged with murder. Investigators believe he intentionally shot his on-again, off-again girlfriend, Emma, and that was her mom right there, talking about the tumultuous relationship the two of them had and how, you know, the parents really weren't, Vinoo, a fan of this relationship. You know, we talked a little bit about defense strategy here, and of course, one of the things that defense always has to be very careful with is this mother obviously is in mourning. You know, you don't want to come off when you ask the cross-examination, you don't want to come off too insensitive when you're the defense attorney trying to question the mother.
I think they have to be very careful. I think this is, but this could potentially be part of their defense, sort of a backdoor way of shifting blame or assigning blame, saying, look, he was driven to these acts because the parents didn't allow him, sort of like a Romeo and Juliet kind of thing, you know, to some extent. Of course, that's extremely dangerous ground, and you may end up, you know, angering the juror. What's interesting is the mother is very calm on the stand, at least the clips that we've seen. I could imagine, I'm a parent, you know, I have 2 young kids, I couldn't imagine that, you know, what she saw, and she's remarkably calm.
I mean, it's just such a tragic situation. Again, if you haven't been following this trial that closely, the night that this shooting happened, Riley is accused of basically jumping a fence, going right in front of Emma Walker's window at her childhood home where her parents were, where her brother was at home, shooting through the window, killing her. Of course, the defense is saying he didn't mean to kill her. And the amazing thing about all of this is that the parents and the brother said they did not hear the gunshot. Let's take a listen to more of the mother's testimony specifically about that night. Just remarkably and horribly tragic situation as Jill Walker, the victim's mother, Emma Walker's mother, described those horrifying moments as she discovers her little girl, her 16-year-old, in that bed, unresponsive, as she calls 911, and then she is later told, Vinoo, that her daughter was dead. Always hard to hear that, especially from the mother of a victim, especially when the victim's 16 years old. She did notice some of the damage, though, in the room, the 2 holes in the wall. She was able to notice that right away, but it seems at first she was a bit confused as to what happened.
Yeah, I mean, it's clear. I mean, you're not thinking anything, right? If you're in her situation, you're not anticipating, you're not thinking anything, and then, you know, what I read is that she touched her foot, nothing, you know, and it was cold, and then she saw what she thought was vomit. I mean, these are just awful things. I will say, from the perspective of the defense lawyers watching this happen, they seem to be, it's not the worst testimony in the world, you know, for their case, because she is relatively calm.
But you did notice, one remark you did make, Vinoo, is that the prosecutor was kind of leading the questions. Yep. It looks like you can see here on your screen that we have a feed back in this trial that's going on in Knoxville, Tennessee. You can see the judge there pouring his glass of water. They're getting ready to call more witnesses this afternoon. This morning there were several minors that we heard from, and we were unfortunately unable to show you any of their testimony because, of course, the judge ordered the cameras off. They are young. Many of the people involved in this case, unfortunately, because it involves high school students, are minors. It looks like you can see in the courtroom the gallery has stood up. Usually that's a sign that the jurors are making their way to the jury box, and I can guess that any minute now we are going to see another witness called to the stand. Now, of course, we're still in the prosecution's part of this case. We haven't gotten to the defenses yet. This is day 2 of the trial. Tell me, you know, as we get towards the defense's case, because we're told this is really not going to be a long case. It's supposed to end on Friday. What kind of witnesses do you think we need to see the defense call in order to make the case that this was not an intentional murder, that he actually was just shooting his gun because he wanted to scare her?
Well, I think I'm not sure who's going to be able to say that, to be honest with you, right? So, you know, because you'd like to have somebody who can say that he had a conversation with the defendant, and they actually really definitely cared. He was obsessed, but he never wanted to hurt her. He never did anything that tried to hurt her. But the problem that you're going to have in all that is just hearsay. And I'm not sure how you get around any of these rules, so I'm not sure the defense is going to have any sort of witness. The only thing that I would think is that you'd want as a defense is some type of scientific or ballistics type evidence to show that the trajectory of the gun indicates that it was not intentional, that this was clearly he was not intending to fire because of where she was, where she ended up. that's the kind of witness I think that you'd go, because the first type of witness, somebody you could say,
and of course, the whole crux of the
gonna be able to do
defense's
that.
case is that this was not an intentional
Right.
shooting, that he was trying to scare her. He wanted to play the hero, the white knight in all of this, and convince her to come back to him by setting up these kind of crazy scenarios. Ended tragically. Of course, the prosecution saying, no way. Absolutely intentional. This was murder. Looks like things have started back in the courtroom in Knoxville. Let's take a listen. It seems like they have some kind of display going on. Let's listen into the courtroom audio. All right, you can see there we went to black, and that is because a minor was called up to the witness stand. And so our cameras are very careful. We don't want to catch any minors and accidentally put their reputation or put their name out there. So we did have to cut off our feed in this case. I'm here alongside Vinoo Varghese. And we were just listening to a back and forth. The prosecutors were reading the text messages that apparently, according to the prosecution's theory, Riley used some kind of disguising app and sent Emma these text messages to freak her out and I guess stage some kind of kidnapping.
Yeah, I mean, again, it goes to the whole background of the crime, all the stuff that leads up to the murder. From the state's point of view, is that this was a guy who was just escalating everything he was doing, and then when he didn't get what he wanted, he killed her.
Yeah, and of course, on the night of the shooting, there's an escalation of even more text messages that he sends her, where he seems to get very, very desperate, and so this particular hoax, I guess you could call it, that the prosecution has entered into evidence, though, may actually play to the defense's theory, though, because the whole theory by the defense is that he wanted to lure her and then come out and say, kind of rescue her, scare her, and then say, I'm here, baby, I'm here. So by presenting this evidence, that kind of plays into the theory as well, the defense's theory.
I think these texts are a little different, right? These are the ones where he's saying that he's the one being in danger, and he's trying to figure out whether she still cares about him, right?
Him.
That's
yes.
his thing. He's testing her, and ultimately, it seems like she does respond. And I think with the other thing of him trying to rescue her, yes, that's the defense argument. Look, he never meant to kill her.
But at the end of this, actually, she comes out of the house to see what's going on,
right?
And he turns up to be there, and so I wonder too if it's not only a way of him trying to see if Emma still cares for her, but also a way to get attention and get her to come and see him in a weird way.
Oh.
Who knows? These are teenagers.
All the above, right?
Lovesick teenagers.
This is teenage angst that I was saying that as I was sitting here trying to think of what a defense theory is I think that's sort of the argument. This is teenage angst, right? This is a boy, you said it earlier, hormones running, who's
rampant.
Who's just really doesn't know how to control himself, and he's lovesick, but he never the last thing he ever wanted to do was actually hurt her.
Because he was just so in love with this girl, Emma Walker, and according to the defense, would never hurt her. He was just trying to scare her. Now, as we wait for court to resume in Knoxville, Tennessee, and I want to thank you because I know you have to dash, for being here this afternoon with us.
My pleasure.
As we continue to wait for court to continue in Knoxville, right now a minor is on the stand, so we can't show that. So instead, I want to show the mother. We just played her a bit earlier, the mother of Emma Walker, and this is the cross-examination when the defense attorneys get their turn to question her about what happened the night of the shooting. Let's take a listen.